Judge just responds to every little thing that I had put on my appeal, and then they put in a motion for a rule to show cause. So because she denied so many things at once, it really complicated the appeal process. And some of the things that she denied were not appealable by right. So there was supposed to be multiple different appeals done, and I was supposed to ask the Superior Court permission to appeal. So now comes the appellant, David Thurston, pro se litigant in the above case. On July 1st, 2024, trial courts filed a rule to show cause challenging appellant's appeal. The trial court's order stated May 3rd, 2024 acts as a final order in disentangling appellant from seeing child. These court mandates are unconstitutional and further denies appellants due process and liberty. Pursuant to PA RAP 311, right to appeal certain interlocutory orders without permission, including but not limited to orders affecting judgments, attachments, and injunctions. Trial courts have repeatedly denied appellant right to due process of law in keeping him from seeing his child while investigating false accusations. Trial courts unlawfully removed the child from the care, custody, and control of appellant on March 14, 2024. The Liberty Clause guarantees both procedural due process, fair procedures, and substantiative due process protection of fundamental right. The Liberty Clause serves as a crucial constitutional protection against arbitrary government interference with individual freedoms and rights. It requires the government to follow fair procedures and have compelling reasons before depriving individuals of their liberty. Trial courts completely relitigated cases and orders from two competent judges of this jurisdiction without finding any facts within these cases. Trial courts completely disregarded the 16 factors of custody, civil rights, the Constitution, due process, and the rules of evidence, ignoring all facts and abusing its discretion and is still causing irreparable harm to the appellant and the child. On March 14, 2024, trial courts removed the appellant's rights temporarily due to a false claim that the courts have no knowledge of a forensic interview conducted on the child. Trial courts have had notice on May 26, 2023 hearing before the trial court judge Tara Toohill, which could be seen on transcript, that investigation was complete and closed. Again, on October 3rd, 2023, day one of the custody trial, Child Protective Services witness number 1, Paige Sears, testified regarding full forensic investigation. See pages 11 and 13, and specifically page 17, line 14 of the October 3rd, 2023, day one of trial transcripts, which states a medical exam was done. Trial courts not only subjected the child to another rape kit, but removed the child from the care of a fit parent and placed into the custody of the unfit parent. The evidence submitted by the appellant and all court transcripts prove beyond a reasonable doubt that the appellee has caused harm and neglect towards the child, lied under oath, and made false reports to public officials multiple times. Comprehensive trial statement of matters and exhibits submitted to the trial courts by appellee shows mom continued to use sexual perpetrator against the child as a babysitter. Mom has made claims of abuse and abandoned child with the appellee after making claims of sexual abuse by the appellant. Evidence shows mom's lack of being able to care for the child on a shared custody schedule is what brought parties to trial. Trial courts now have given mom full custody, and mom initially only wanted 1 week on, 1 week off. Appellant disagreed to 1 week on, 1 week off due to child being special needs, and child neglect or abuse cannot be verbalized by a child and is mostly seen through nonverbal communications. It is understood that hearsay can be weighed in family court matters, but all factual evidence against the appellee has been ignored by the trial courts, and all hearsay evidence against the appellant has been accepted as truth. This abuse of discretion by the trial courts violates due process and equal protection under laws. Appellant has filed a motion to vacate March 14th order, a motion to reconsider, an emergency petition for relief, and a motion to recuse. All motions were denied, and an order dated May 3rd granting mom full custody. Appellant and former pauperers had the option to see the child between 1 and 4 hours per week, ordered to pay out of pocket $80 per hour. Despite the financial distress imposed on appellant, the court-appointed professional supervisor has scheduled one visit on May 16, 2024. Appellant has called and texted multiple times a week to schedule a second visit. The court-appointed supervisor would promise a visit and then does not show up or cancels. Currently, as of July 11, 2024, the court-appointed supervisor will not text back, return calls, and has relayed to the appellant he has a busy schedule with his kids and other programs that he runs. Not sure why this judge appointed me. Appellant has seen the child one time since March 14th, and the trial courts have cut off all phone communications. Furthermore, this location appears to be an abandoned building, and inside there were water leaks coming from the ceiling and buckets in the visiting room to catch the water. The court has also ordered appellant to drive 1 hour away from home for mental health evaluation to be paid out of pocket $140 per session and to pay for appellee's counseling $140 per session. This court has subjected appellee to cruel, unusual, unwarranted psychological and financial punishment. My daughter has been fraudulently taken away from me. This is not hard to prove, and the trial courts are aware of what they are doing. Trial courts' void orders have also caused fear and intimidation to child's caseworkers. School teachers also have no obligation to speak to appellant due to trial court orders. Any and all third parties involving child are in fear of job loss or retaliation for giving me any updates on child's well-being. The appellant has no clue of the safety or well-being of the child or contact with anyone who can relay child's well-being or safety. It is evident what is happening. Examination of all evidence that I have provided to the trial courts and the record will show that trial courts are abusing their power, discretion, and have completely abandoned oath and not upholding the Constitution, civil rights, the Child Abuse Prevention and Treatment Act, and the Americans with Disability Act. The trial courts are deliberately depriving appellants' rights under color of law, which violates Title 18 U.S.C. Section 242, Deprivation of Rights. The trial court's unlawful communication with the appellee's attorney and stenographers, withholding transcripts, are further deprivations of rights and violates Title 18 U.S.C. Section 241, Conspiracy Against Rights. Based on the trial court's March 14, 2024, May 3, 2024 order, statement, and transcript citations mentioned above, appellant respectfully requests recusal of the trial court judge and reversal back to the original 2019 custody order until a new impartial judge is assigned. A new trial pursuant to civil rights violations 42 PA CS 8309 and prohibition against deprivation of rights 55 PA Code 260043. Section 1983 of the Title 42 of the United States Code 42 U.S.C. 1983 provides remedy for individuals whose federal, constitutional, or statutory rights are violated by persons acting under color of law. I have the understanding that pro se litigants should be held to a less stringent standard than formal pleadings drafted by lawyers. The Supreme Court has indicated this suggestion that courts should be more lenient in considering evidence presented by individuals representing themselves. I admit that the amount of mental fatigue, calendar, and financial distress that trial courts have subjected appellant to is causing much difficulty in keeping up with all the possible technicalities, legal theories, and law. All I want is for my parental, civil, and constitutional rights to be upheld in a fair and impartial trial. Appellant is doing everything in his power to protect and defend the child, but if the child is going to be subjected to continued harm in dangerous circumstances due to the legal technicalities, fundamental fairness demands that the court appoint a lawyer. My daughter is in a very bad predicament due to negligence of the trial courts. This can be proven beyond a reasonable doubt if given the opportunity to be heard in my brief, which is due August 7, 2024. As stated in the appellant's statement of errors, I would rather my parental, civil, and constitutional rights be upheld before brief due date.